It's a very good opportunity to discuss the practical aspect of the case laws. Everybody is getting always by some way from source like some case studies and all the things. But the thing is the practicality and how a case will twist and how a case will turn and what is the way and what are the requirements is required. Because basically in our insolvency segment, IBC area, the practicing respected chartered accountants and respected company secretary, lawyers, as well as some retired bankers, they have the sufficient knowledge, but the playground in the court is different to act sometimes different way, different culture, and different things is available. So today what I will do, I will take this seminar in a very practical way, sir. So everything will be in practical manner. Any aspect with my best of knowledge, I will explain all the things. So today, Shravani, she is a final year student in KIT University, KIT Law College. She will assist me regarding some of the portion to read and as well as to explain. So major parts I will take care. So before going to this, and I have to explain one thing that in IBC, this is a procedural, this is a process. This is not a proceeding. Everybody has to understand. And we are working with our authority who is a quasi-judicial form. So this is very important. We have to understand where we have to work. We will work with a quasi-judicial form and we will work for a process, not for procedure. And IBC is it is a special statute, special structure, special authority, special time. Everything is special. This is special. Also, has taken the special peoples like experience, more than 10 years experience, were in field. So, what is the thing is that first of all in the IBC, we have the knowledge for the process. If there is something slipping from process, that will make a conflict. Who are rivals? Who will make the conflicts in our area? And who will understand that basic concept we have to understand. The first thing is that we are working with a quasi-judicial firm. One is technical member, one is judicial member, and IP, RP, and corporate debtor, and also third party and resolution applicant, prospective resolution applicant, successful resolution applicant, committee of creditor. These are the peoples we have to day-to-day access these peoples, and we have to understand in the process. In the process, what are the difficulties will arise? They will approach to our authority, that is NCLT or whatever things. So now, this is the thing. The first case I am going to explain today. Go through that. So when you start this case one. Yes, sir.
Am I audible?
Yes, ma'am, we can hear you.
Okay.
So the first case today we'll be dealing is Sanjay Pandurang Kalate, who is the appellant in this case, and the respondents will be Vistara ITCL India Private Limited and other respondents. So if we go to the brief facts about the case, so the appellant along with his father and brother.
Madam, in your opening slide, I think the spelling of Vistara is incorrect. You may like to check.
I will surely say.
And we are not able to see the PPT.
Yeah, we are not able to see the
PPT is not visible.
Sure.
Please share again.
PPT is not visible. I'm not able to see the PPT.
Oh, fine, thank you.
So if we go to the brief facts about the case, members, am I audible to you right now?
Yes,
Yes,
yes.
ma'am, you are audible.
Audible, but please keep on moving your slides with what you are saying.
Surely, sure. Yeah. So if we go to the brief facts about the case,
Apologies, ma'am. Apologies. If you can put it on a presentation mode, we would be able to see the entire content. Apologies. Thank you.
one second. सर अपन कैमरा ये करें तो मैं now is my PPT visible in presentation mode?
No, ma'am, sorry.
Not appearing on screen, madam.
One second.
Yes. No.
Thank you.
Now it is visible.
Again, in third line, madam, you may have to correct the spelling of Vistara. Just telling you.
Surely, sir, will correct the spelling of Vistara first. So the appeal was filed under Section 61 of the IBC by Sanjay Pandurang Kalate, and it was in pursuance to the order that was passed by NCLT Mumbai bench. So the adjudicating authority admitted the application under Section 7 of IBC by Vistara and initiated CIP of the corporate debtor, that is Evident Developers Private Limited. Aggrieved by this impinged order, there was an appeal filed by Shri Sanjay Pandurang Kalate, who was a suspended director of the corporate debtor. Sanjay Pandurang Kalate, along with his family, they partnered with Jayant Vallabhdas Kameria and Dheeraj Lal Govardhan Das Hansalia. So they partnered to develop a residential and commercial project in Pune, and they formed based on that partnership, they formed the EDPL corporate debtor to develop the project Panorama and project Vedanta. So the corporate debtor authorized the issuance of 5790 fully secured, redeemable, non-convertible debentures with Vistara ITCL as a debenture trustee. The debenture holder was India Realty Excellence Fund, and it invested around 34 crore 41 lakhs. However, the corporate debtor, it began committing defaults in payments, and it failed to pay the payment, and due to which the redemption of the NCDs amounting to 65 crores approx was failed, and hence the application under section 7 was filed by Vistara. Now the question of law, if we go, that what will be the scope and jurisdiction of adjudicating authority? So the question of law here was the scope and jurisdiction of adjudicating authority under IBC, and what was the nature and whether it was extensive of the civil procedure, and to inquire the disputes that arises out of the MOU, that is the memorandum of understanding and related specific performance. So here in this case,
Okay, thank you, sir. That is I apologize for that mistake of the spelling mistake. Okay, so I think we'll continue. This thing is that the thing is that when section 7 application will come to the board, a very interesting thing. When a section 7 application will come into the board, what are the, suppose in the stage there is no role of the IP, because section 7 application is particularly filed by the corporate, that is the financial creditor. So in this matter, though, before we have some practicing people like chartered accountant, company secretary, and also lawyers and my friends who are practicing in representing with the NCLT. What are the steps we have to take before filing a section 7 application? It's a very important thing. If you go to the section 7, you will find in IBC section 7. In the section 7, subsection 5, it is clear. When an application will be made to authority, the authority has to examine a default has occurred and application under subsection 2 is complete, and there is no disciplinary proceeding pending against the proposed resolution professional, it may by order admit such application. There is the jurisdiction of the authority is to examine first whether there is debt or not, there is default or not, the application is complete or not, or the proposed name of IP, there is no disciplinary proceeding against him. Or nowadays we keep going on, that is AFA, that is valid AFA should be there. This is the very important things. In this case, so whatever the facts, the question is arise that there is some dispute. There may be some dispute. The learned lawyers, learned representative of the corporate debtor has shown there is a number of disputes. Something is going on, so section 7 could not be admitted. Another very interesting point is that they admitted that they were financially incapacitated in repaying the outstanding of debt on their own step and were trying to mobilize resources to liquidate their debt. It's a very interesting point. If someone is making argument in section 7 application that my authority has to understand that I am a going concern, there is number of employees and I am due to some reason, this is financial distress and I could not pay. So that is, I could pay it after some days by making some financial arrangement and trying to mobilize resource to liquidate the debt. So at that time, the authority or the bench will clearly understand this is a case, solid case for CIRP proceeding. Most of the corporate debtors, they are thinking CIRP is a proceeding. It is not a proceeding, it's completely process. So we are filing section 7 applications, not suit or. So in this case, when the very important thing, the decision of Honorable NCLT Delhi, this is the case, this is the judgment. The corporate debtors Sahoo required to revive themselves by acquiring investors, indicating financial incapacitance in repaying the outstanding debt. Sir, all my respected member has to understand.
Excuse me, sir. Please pardon me. You are not sharing the screen which you are reading. If possible, you may share that screen also.
So the PPT is only being read and it is being shared only.
Sir, reading the content is different from this.
Sir, I have gone through only section 7, clause 5. Everybody knows. I think.
Okay, fine. Then fine.
Because
Thank you.
sir, what is the problem? The different things, different systems I have collected. I am saying that.
No issues. Just I was bringing to your
Apologize,
knowledge.
apologize, sir. Sir, apologize.
Sir, if you could give para numbers also, then we can refer to that.
Yes. Suppose we have downloaded the judgments or the orders from IBC law. If you have the IBC law, then I can go. Otherwise, original judgment I will follow. I will say the para number. It will be good for everyone, I think. Sir, the thing is that, sir, I am stressing only the question of law, sir. So we'll take part all the peoples and we'll sure.
Please go ahead, sir. Please go ahead.
Sir, only the question of law I am going because I know everybody is getting every day many cases, many judgments by various sources. Okay, sir. So, but my stress is that I have to stress on the point of the question of law. Sir, okay, sir, we'll sure anything, sir, we will participate and we'll discuss no issue. Sir, section 7 application as the degree of the proof of required for providing transaction to be eligible and fraudulent should be. Sir, I have told in this fact that corporate debtor has taken lots of plea that there is some disputes, many things is happens, but according to section 7, the authority is strict and authority has relied on the section 7 subsection 5. There is a debt, there is a default, nothing is pending against the resolution professional as well. The application is correct, so they have admitted the application, and the adjudicating authority found no infirmity in admitting the section 7 application, even if the appellant contention that there were serious internal disputes among the respondents cannot be and reasonable ground for denying the financial creditor their right to claim payment towards the debt owned by the corporator. The appeal was dismissed. So if you have these facts, you can go through that facts and you will get whatever the submission made by the learned respondent and applicant representatives. The conclusion was there was a serious dispute between these people, and section 7 does not allow the dispute part because it is completely depends upon the as per section 7.5 what I explained, that is one is debt, another one is default, another one is complete application, another one is not proceeding against resolution professional. So another point in this area in the judgment, it is clarified that the corporate debtor has admitted that he is financially incapable to repay his debts and he wants to my camera, he wants to collect the funds from outside. That was the question. So accordingly, Honorable NCLT has dismissed this application and offered the NCLT. This is the thing is that, sir, I would like to explain another such type of cases. What I was handled recently. Can my camera?
Camera is-
So here, sir, you just said there were serious disputes among the respondents. How does that matter?
Okay, sir. Sir, you serious dispute. Whatever the dispute, this is summary proceeding, sir. First of all,
Okay.
summary proceeding does not allow to enter into the what is dispute. In section 7, admitting an application, there is nowhere mentioned the authority has to be find out the disputes, whether dispute or not. Only 9.
Yeah.
So in your practical life, this is the very simple. This is the art of science that you should have to, if you will go for a SC test of a section 7 application, only the basic fundamental concept is that depth is there or not, default is there or not, limitation is not there or not, or this is a application is correct or not, and another one is whether there is any proceeding against IP or not. This is the basic rule. These thumb rules will be applied by authority, nothing else. One example, sir, recently I was handled one case where this was a medical, the big medical during that, and there was the default of the 68 crores. Before that, what happens? There was a joint, the financial creditor has issued the notice section, issued the notice that to repay the debts, but they could not pay and they filed the application with authority. In between, the corporate debtor has made one MOU with government of Chhattisgarh to take over that. The government has to take over that medical. Section 7 already filed. Now there was a MOU with government to take over. But the learned advocate for the respondent argued that. So state government has made a MOU as well as a notification to take over this hospital. But our argument was that I came with a clean hand that whatever I have given the debt, that is admitted, limitation was there. So, not taking consideration of other facts, this application is to be admitted. Then that application was admitted during that time. So, you can see that order NCLT Kotak bench, Chandulal Chandakar Memorial Hospital versus Central Bank of India. Next slide. Start this.
So the next case will be EDAC Engineering Limited versus Industrial Fans India Private Limited and others. In this particular case, EDAC Engineering is the respondent in the arbitration in the arbitration proceedings, and Industrial Fans is the claimant. So there was an order dated 23/2018 passed by the court. The arbitrator was granted liberty to fix the fees, and both the parties to the dispute participated in the arbitration, which culminated in the passing of the arbitration award dated 30/4/2021. Industrial Fans had paid its portion of arbitration fees and costs. However, EDAC Engineering failed to pay the balance arbitrator's fees and cost. So the arbitrator had excised his statutory lien, and as per the provision of section 39(1) of the Arbitration Conciliation Act, for non-payment of his fees by the applicant. The arbitrator had not delivered the original award to the applicant, but has delivered the same only to the first respondent, and which they had paid the arbitration cost and fees. So the agreed by the same under the Act, these applications were filed under Section 39(2) of the Arbitration Conciliation Act, seeking for the release of the lien and for revising the fees and costs payable to the arbitrator by the appellant, which was not paid by that. The question of law.
The question of law is starts. Sir, everybody, I request to everybody can discuss these things. This is a very interesting part, and we have to learn that also. Fees payable and arbitrator has to be treated as CRP costs and to be treated as preferential payment. Moratorium under Section 14 of IBC does not apply on fees of the payable to an arbiter. Sir, all of us and the experience during moratorium, whether we could pay some fees to any past fees or not. I request to everyone to will join to discuss in a vibrant way, sir. It will cooperate, otherwise I will read, nothing will happen. And I request to all my seniors and my friends, we could discuss the things. Fees payable to an arbitrator has to be treated as CRP cost. And
No,
yes, sir.
no, it will not be treated.
Yes. As
I
per
will
your
try.
view, oh, yes,
You
sir.
have your own good.
So we will not treat as CRP cost, sir.
Yes,
Okay,
sir.
Sir, any favorable, sir? Anybody, any learned friend or learned senior, sir? This is sir told that it should not be treated as CRP cost. And any favorable that it could be treated? Sir, we have to discuss first whenever a IP. Sir.
I'm saying it may not be treated as CRP, but it should not also not be treated as preferential payment, because how does it fall within the definition of preferential payment?
Preferential payment. Okay, fine. Preferential payment. Your concept is
it should not be treated either as preferential payment.
okay.
And the award, I may have to ask you a few questions. If when the award when the arbitration commenced and
Yes.
proceeded, was it during the moratorium period, that is prior to CRP, or during the CRP?
During CRP.
During the CRP. So RP consented to participation in the arbitration.
Yes.
RP consented to the participation in the CRP, sir?
Sir, two cases we will discuss. One is your suppose during the CRP. I am not going to that case. I am going to practically only we have to take care. Sir, that case we will discuss. The question is that, sir, my point is that, sir, now I have received one assignment where
Yes, but you will have to ask the questions to ascertain the facts, sir. To
Yes,
answer
yes.
the
Here-
question of law.
Which I have understood that the arbitration award was given prior to the admission order of the
Yes.
CIRP.
yes,
Section
It is,
7.
if the award is prior to the CRP, then how will it be part of CRP cost, sir?
That's why I said no. So we'll come to.
But it
we'll-
cannot still be coming under preferential payment. That also I am saying. So it's, sir, actually the question of law, as you are learned yourself, depends upon the facts that you present before.
this
How, sir,
type of
आपकी आवाज गई?
yes, yes. Now audible, sir. Sir,
Yes, sir.
This is a question of law, sir. Then we'll go to the fact. Don't worry, sir. This is a question of law that everyday practical life, one IP has, suppose one IRP has recruited, there is 2 point, IRP finds that there is arbitration is going on, some pending fees is there. Another part, as per sir, suppose IRP recruited and found that the arbitration proceeding has to continue. The fees of arbitrator. Sir, I am not going to that case. Now I am going a question of law. We'll first clear this point. If it is my process will be wrong, then I could change it immediately other way. So
Sir,
my
can question of law exist in the vacuum in a case law?
yes, it is related to our squarely applicable to our case of law. First, we have to clear this point only, sir. Then we immediately will get the close view of our case of law. Okay, sir. So in this case, sir, fees. Suppose IRP has recruited and found that there is arbitration is going on, some arbitration fee is pending, and the arbitration will continue in the CRP period also. Then whether we will treat this fees as CRP cost or not? That is the question, sir.
My question to you was that did the RP participate in the arbitration during the CRP period, or did he raise the issue of moratorium?
Yeah, sir, Sahoo sir may mean to say that RP consented to continue the arbitration activity. So if this is the case, then the fees will be, if approved by COC, will be the CIRP cost, because this will be similar to the appointment of the professional for the assisting RP. So we may call them arbitrator, we may call them independent professional, whatever the name we may call, which basically for admission of the claim, it is the facilitation of the claim. But one view may arise that if we consider that as a claim, then in that case, cost of processing the claim will be borne by the parties.
Yes.
So these are the two scenario arises from this point.
Right, sir. Right, sir. So I am creating two scenario. One scenario, before CRP or arbitration cost is pending, and during CRP arbitration cost is going on. That is true scenario. Sir, as the moratorium period, it is clearly written in the CIRP cost, it includes essential goods and services, sir. This is very important point, sir. It will clear our picture. During CIRP period, whatever that is CRP period, what is the essential goods and services, both are there, essential goods and services. So arbitration or arbitrator fees is a essential service, treating as this court has declared that this should be incurred, this should be treated as CRP cost. Someone read this decision.
So the applicant raised
हाँ बेटा
concern.
Yes, yes, sir. Continue.
The applicant has raised concerns about the arbitrator's fees as moratorium under Section 14 of the Insolvency and Bankruptcy Code has been passed by the NCLT. The Honorable High Court ruled that NCLT's moratorium order does not prohibit the insolvency professional or liquidator from paying the arbitrator's fees, which were due in the previous year 2021. The arbitrator fees must be treated as cost incurred for the CIRP process and not be deprived of the agreed upon fees. The arbitrator's remuneration and fees for administrating the liquidation process must be paid first. Section 14.2 of the IBC also states that supply of essential goods or services to the corporate debtor shall not be terminated or suspended during the moratorium period. And the IBBI also issued a circular stating that the fees payable to an arbitrator appointed by the court cannot be held reasonable. The arbitrator's fees must be treated as priority payment and their services rendered during the arbitration and the pronouncement of arbitral award cannot be deferred or deprived.
Sir, this is the treatment has taken of arbitrator fees by Honorable Court, that this should be treated as CRP cost. Sir, anything to add on? Sir, anything has to be added on this or any next?
The case is Entity Data Business Solution Private Limited versus Trident Limited. So in this case, a notice under Section 21 of the Arbitration and Conciliation Act was given to the operational creditor, which is dated 14/6/2021. The cooperator in the arbitration clause and appointed an arbitrator. The notice of arbitration was replied stating that there is no dispute between the parties. The appellant therefore gave a notice under Section 8 of IBC and thereafter for Section 9 application. The adjudicating authority rejected the application, holding that there is a pre-existing dispute between the parties. The adjudicating authority has examined the issue of the pre-existing dispute and noted that the notice of arbitration was issued on 14/6/2021 and notice under Section 8 of the code was issued on 21/6/2021. That is, much before the demand notice of arbitrator was appointed. And the NCLAT also, Honorable NCLAT also upheld the decision.
Sir, now I am showing this original judgment, whatever the downloaded, so it will be interesting. Sir. Please, I am sharing the total order now. Okay, fine. So completely down. Okay. Pura first. Pura color. Which one? The original order. IBC. IBC. Sir, in this case, a notice under Section 21 of the Arbitration and Conciliation Act was given to the operational creditor on so and so date. The corporate debtor invoked the arbitration clause and appointed an arbitrator.
So this is very important fact, no?
Yes.
But it is the CD who had invoked the arbitration. So question of moratorium does not arise.
So this is another case I am discussing, that is the Entity Data Business Solution Private Limited. Okay. So that case.
Now, sir, this case you would wish to tell us through this case
Yes.
that if there is some request for arbitration is raised by the corporate debtor, and after that request, an operational credit deny that request and issue the notice under section 8. So
Yes, yes,
this
yes, yes,
will considered by the adjudicating authority as dispute, raising
yes,
the dispute,
yes,
and that's why they have rejected the application. This you want to convey to us.
yes, yes. That was why the Indra bench.
Thank you, sir. Thank you, sir.
So the thing is that here, what is the twist of this case? I want to going to say that, sir. I told you, sir. Everybody is getting some information by measure ways. But what is the twist of this case? In this case, what happens? The applicant thereafter gave a notice under section 8 of IBC and so answered that after file section 9 application. The authority rejected the application holding that there is a pre-existing dispute between the parties. The authority has examined the issue of pre-existing dispute and noted that notice of arbitration was issued in the year of 2021 and notice under section 8 also issued after only 7 days. That is much before the demand notice of arbitrator was appointed. So the thing is that the corporate debtor, the operational corporate debtor has issued the notice of arbitration under section 21 of Arbitration and Conciliation Act. After that, the operational creditor has filed section 9 application, or sorry, issued the section 8 notice to file a section 9 application. So section 9 is the very important part is dispute. If there is a dispute, it will be testified, it will be tested, then the application will be rejected. If it could not test, then the application will be admitted. Here, corporate debtor has issued notice section 1 of Arbitration and Conciliation that the service provided which has some defective, so they want to go for the arbitration. But the operational creditor issued the section 8 notice and filed section 9. So this is the concept. So here is the when section here, what was the contest was happened in this application, that is important. Sir, in the section 21 notice when the corporate debtor has issued, at that time, the operational creditor has given reply that there is no dispute. But in the court, examine and find out there is some pre-existing dispute. So this application was admitted. And same has been challenged with Honorable NCLT. And Honorable NCLT has find that we have looked into the notice dated 14th June 2021, which was issued by the corporator. Notice in detail point out the deficiency in service and has thus given a notice to resolving the dispute between the parties by means of arbitration. The mere fact of the notice arbitration was replied by the operational stating that there is no pre-existing dispute, cannot be reason for ignore the dispute, as well as raised in the notice dated 14th June 2020, which is elaborate and details of deficiency of the in the service as per the corporator. Sir, why should I? This is a very simple case. Sir, what is the twist point and why should we discuss this case, sir? So this is a case very interesting, and when the corporate debtor is issuing a arbitration notice, at the time of arbitration notice, the operational creditor is saying that there is no dispute, nothing is there. You have to, I am clean, you have to pay. Because I have worked everything. So first, in this case, when there is a arbitration notice has issued and if that is the evidence of dispute, the court will not enter into the dispute area and not make the not judge the what the dispute has happened and what is not happened, but court assumes whenever there is a notice under section 21 of arbitration has issued, there must be a dispute. The prima facie this case has to be rejected. In this year, so this is an interesting case where corporate fine operational creditor also send notice under section 8 that he is now assuming that I am clear that in the arbitration notice I have replied, there is no dispute. Sir, question is that in the arbitration notice, the operational creditor is clearly written there is no dispute. But court is assuming that mere reply of the notice of arbitration notice cannot be treated as there is no pre-existing dispute. So this actually has admitted, sir. Sir, anything, sir? Anything you want to add, sir?
So what was your final communication that this application has been rejected or accepted?
This appeal is dismissed, but application is admitted, sir.
Appeal is dismissed. It means that arbitration notice of arbitration was held valid for the as a dispute.
Yes, sir.
Thank you, sir.
Sir, mere replying that there is no dispute in the arbitration in the court of law, they will not accept, and as per our learning, that mere reply of arbitration notice that there is no dispute. So court will accept that if you have issued notice for arbitration regarding some dispute, because sir, it's a very valid point is that before issuing the section 8 notice, the corporate debtor has issued the already, that is section 21 arbitration notice. So it is a pre-existing dispute.
Thank you, sir.
Section 1 minute. So there is a interesting, very interesting case. Sometimes it is not comes for everybody opportunity such type of assignment. That is this case. So this is a we have to understand this is a suppose for the last segment and last sector. Sonico structure.
The case is Soneco Marketing Private Limited versus Girish Shriram, Juneja, and others. So the facts of the case is the RP had received resolution plans from two PRAs, that is prospective resolution applicant, Independent Sugar Corporation Limited and Greenpack Limited. So Independent Sugar Corporation Limited sought clarification of the RP with regard to the approval of CCI as well as the timelines for obtaining such approval, as the RFRP had contradictory clause. The RP issued a clarification that in light of the available jurisprudence, the RFRP granted relaxation to the resolution applicants to procure the CCI approval post the approval of the resolution plan by the COC. But prior to the filing of the resolution plan before the adjudicating authority, Independent Sugar Corporation Limited received the requisite approvals from the CCI to the approval of resolution plan by the COC. However, the application filed by AGI Greenpack Limited was declared as not valid by the CCI. Later, the resolution plan submitted by AGI Greenpack was approved by the COC. Accordingly, application for the approval of resolution plan was preferred before the learned adjudicating authority. In the meantime, Independent Sugar Corporation was also preferred an application before the adjudicating authority seeking setting aside the selection of the resolution plan submitted by AGI Greenpack Limited. However, the CCI granted approval to the AGI Greenpack Limited subsequent to the approval of resolution plan by the COC. Thereafter, the adjudicating authority rejected the application filed by Independent Sugar Corporation Limited.
So the question of law is whether, as per section 31 of the code, the requirement of approval of the CCI prior to approval by the COC is mandatory. Sir, I hope most of the respected chartered accountant and company secretary will be there. This is a very big area, CCI. CCI practice is very for the less in India, less people in India. So because there is a turnover and there is some landmark for the land benchmark for the turnover as well as asset value, all the things. So whether as per the section 31 of the code, the requirement of the approval of the CCI prior approval of the COC. In the plan approval, there is some mandatory approvals of the required. So in this case, the question arises before approval of a plan by the COC. Sir, by the COC, not by the court. It is mandatory or not?
They can seek the approval of CCI within 1 year of adjudicating authority approval, isn't
Sir,
it?
correct, sir. Correct you, sir. Sir, in this case, what will happen, sir? Suppose one RA came, he submitted the plan, and plan will be go to the COC members for approval. Approval with CCI is required sometime. So already IBC is a time one process. So whether this will be treated as mandatory or directory. This is the main thing, sir. So as per the next decision of the authority, appellate authority held that the RP has subsequently clarified that approval can be obtained even after the approval by the COC, which was in accordance with the prevalent legal position as settled by the NCLT in ArcelorMittal versus Abhijit so and so, wherein the Honorable NCLT had held that proviso to subsection 4 of section 31 of IB code, which related to obtain the approval from the CCI under the Companies Act, Competition Act 2002, prior to the approval of the such resolution plan, the Committee of Credit Director and Manager. It was already settled, sir, in the case of the ArcelorMittal India Private Limited versus Abhijit. It is already settled, and very interestingly that the RP has done a perfect work in this case where he has
Sir, one request is there. One audio disturbance is coming from Kushwinder Singhal. So I'm unable to listen your voice, sir. Sir, his audio should be get muted, Kushwinder Singhal. It is creating disturbance, sir.
Yes, sir. I have no admin power. I request to Anjali ma'am. She has to look after these things.
Sir, already.
Okay. Thank you. So this thing is that, sir, in this case, whether there is a directory or a mandatory, it is already decided. Already it was decided, but that is the same squarely applicable case that ArcelorMittal and code related to obtaining the approval of the CCI under the Competition Act 2002 prior to the approval of such resolution by Committee of Credit is directory and not mandatory. Sir, directory not mandatory. Mandatory होगा तो sir time consume करेगा sir, right or wrong sir? Sir, CCI approval, before approval of the COC, if the plan will go to make a approval with CCI, then it will consume the time also. And also court has taken the good view, that is this is a directory and not mandatory. So, and RP in this case, RP has learned, RP has made in a very perfect way that he has given the things in RFRP that within whatever my learned senior has told that within 1 year it could be happen. So this case, according to this case, further the NCLT held that it's open for COC which looks into the viability, feasibility, and commercial aspect of resolution plan to approve a resolution plan subject to such approval by commission, which may be obtained prior to the approval of the plan by the authority under section 31 of the code. Further, the appellant authority held that section 31 subsection 4 provision has read to mean that approval by CCI is mandatory. The approval of CCI prior to approval of COC is directory. Thus, the appeal was dismissed. सर, CCI का काम सर हम लोग सर कितना IP लोगों का आता है, ये नसीब में एक एक आता है सर, राइट सर? Sir, audible sir?
Final conclusion is the directory, not mandatory.
Yes sir, director. My question is sir, this type of work, how many comes in your career? I think very least number of things comes in our career, no? Because the high value for the high value cases. So sometimes
Large firm that they get this type of assignments.
Yes, this is for the high, and learned RP has made a very good in this case that he has stood these things in RFRP, which is a very vital document, which was that means that is consent of COC has given. In the RFRP, he has mentioned this document. Sir, interesting thing is that we need to discuss some practical approach. Suppose this is the case, we will discuss 2 or 3 more cases. So one, I hope all my learned seniors and friends in participating in this event. Sir, one question, sir, I would like to put and I like to discuss. I want to get knowledge and we'll discuss also. Sir, one section 9 application was admitted. Sir, this is a case study, sir, I am telling, sir. Sir, should I get a permission from everybody that to discuss this case? Hello?
Please, sir, go ahead.
Sir, I'm submitting one case study, very interesting case study, sir. This is section 7 9 application was preferred by one proprietorship applicant. Sir, I'm saying section 9 application was preferred by a proprietor firm against a private limited company, whatever. Suppose after that, this was admitted and CRP was started. Then, sir, I am concluding that CRP was started. Then what happens? IRP made public announcement and got the claims. In that claim, IRP has received, the last date of claim was on the last day. He has received 1 financial creditor claim and 2 operational creditor claim, including the applicant, that is 3 operational creditor and 2 financial creditor. So what happens now? The corporate debtor has made one proposal with the applicant to settle the issue. Simultaneously, they prepared, the applicant has agreed, and they prepared FA, like the withdrawal application, and came to the IRP. And IRP is bound to file application under section 12. Sir, a very peculiar situation arises here. What happens? IRP has received the financial creditor claim on the last day of
CIRP.
claim. Sir, not submission of the claim as per form A.
You mean 21st day of the CIRP process, no?
Yes, yes, yes.
Before 30th day, in the absence of the formation of COC, the
Yes,
applicant can withdraw the application.
yes.
Before formation of COC, regulation 30A something is there.
Yes, sir. Before formation of the COC, now it is concluded. Before formation of the COC, the withdrawal application has filed with authority. Now, sir, one of the financial creditor has made implead a intervener application stating that I have submitted my claim. How could this application will be withdrawn? Then what the scenario will comes in the court? Sir, whenever the application, my argument was, suppose, my argument is that, sir, my right, the corporator, I am suppose acting for the corporator, my right to withdraw the application, nobody can stop. But bank, the financial creditor is stating that I have given the claim. So how could, without my consent, the application could be withdrawn? Any, in this situation, any scenario, in this situation and scenario, any advice, sir? Any senior, sir? Or any my friend of anybody, sir?
As per the Act, it is very much clear that before formation of the COC, the applicant can withdraw this process.
Yes.
But after formation of the COC, because they have not mentioned that after receiving the claim.
They have mentioned only after we have submitted the claim.
That is not mentioned anywhere in the Act, as per my knowledge. Simply,
Yes.
it is mentioned before the formation of the COC, the applicant can withdraw the process.
Yes, sir. This is the right of the applicant. He can withdraw that. But here is the question. The financial creditor is making the argument that I have given the claim. The IRP could make the COC, and where that I could get a right, where I could within 90% I have the voting right, and this application cannot be withdrawn as per the bankers, the financial creditors argument. But the 30 days required to make the as per the our code and our regulation, the IRP has done. After receiving the application, IRP immediately cannot include the person into COC because he needs some time. I think 7 days or 14 days, whatever days, 7 days to finalize the application. So in this case, the financial creditor stand would not be sustained due to that he is neither a member of COC nor his claim has been admitted or reflected in the that is a committee of creditor. So before the committee of formation of the committee of creditor, there is the right of that applicant, the corporate debtor or applicant, they can settle the dues and they can withdraw the case also.
As earlier you have told that this is the process, not the proceedings. So
yes, sir.
As per process, within 30 days the application can be withdrawn.
Yes, sir.
But
Sir,
what is held by the adjudicating authority or appellate authority?
Sir, what happened in this case? appellate adjudicating authority, what happens? So they allow my 12A application, but the intervenor application they kept in pending. I think when 12A application main CP in the 12A application, the application has withdrawn. The main CP is now there is no existence of the main CP, so this intervenor application will be also dismissed.
Have they gone to appeal?
No, no,
Financial-
no.
They have not.
Sir, no, they have. If they will go also, if the ground will be they could not be intervened, as well as there is no COC formed, as well as even if the claim has not been admitted by the IRP, only the acknowledgement of receiving of the claim has been issued by the IRP. So in that case, in this case, the application was withdrawn, and as well as the main CP, there is no stand of the main CP. So I think this intervenor application must be influenced also or dismissed. Next question. Next.
So the case is Mayura's Industrial Service versus SR Shriram Shekhar. In this case, the appellant, who was an operational creditor, had preferred an application under Section 9 of the Code for initiating the CIRP against the corporate debtor. The same was admitted and thereby CIRP was initiated. However, subsequent to the commencement of CIRP, the COC had passed a resolution for withdrawal of the CIRP. The RP in furtherance of the same had preferred an application before the learned adjudicating authority under Section 12A for withdrawal. The said application was allowed that it becomes pertinent to mention that the RP along with Section 12A application has not filed Form A. Aggrieved by the same, the operational creditor had preferred an appeal before the Honorable Enclave.
Question of law: whether the adjudicating authority was correct in allowing the withdrawal of the CRP without hearing the appellant.
Sir, there is a gap in the question. Whether COC has passed the resolution more than 90% voting? It is assumed.
Yes, yes.
They have passed
90%.
the.
Yes. That gap is there. That I am going to continue. But the fact of the case. See this fact. Again discuss this fact.
Sure.
1 second, sir. We are continuing this.
Operational creditor had preferred an appeal as an agreed person in respect of the impunged order dated 2/11/2022 passed by the NCLT Division Bench. 2. Before the adjudicating authority, the IA was filed by the resolution professionals seeking for an order for withdrawal of CIRP initiated by the petitioner by an order dated 16/3/2022 in a main company petition resting upon the resolution passed by the COC in the third meeting that took place in 6/6/2022 for accepting the order of settlement submitted by the corporate debtor and for withdrawal of CIRP as per Section 12A of the Code. The learned counsel of the appellant submits that without receipt of any consent, that is Form FA from the appellant who initiated CIRP, the IRP should not have passed a resolution for withdrawal of the CIRP. The principle of natural justice was not adhered to by the adjudicating authority, and without furnishing any detailed recording of the objections predicted by the appellant, the impunged order came to be passed in a mechanical manner.
Sir, here the second option case, the first we discussed within 30 days before formation of the COC, if anybody also coming any financial intervening, that there will be no chance. That stage, applicant has the right to withdraw the application. Here, already COC has been formed. Here the objection is that when COC has been formed also, the appellant has to be given consent or NOC or consent, whatever, to withdraw this application. This is this case. Sir, question is that suppose section 9 application, operational creditor, operational creditor may be participate in the COC or may not be participate in the COC as per their stake or claim. Okay. So that means all the financial credit, suppose this is all the financial creditor and the operational creditor as per the code will be constitute the COC, and the power of withdrawal of the 12A will come under COC, that is 90% of the voting. In this case, 90% of the voting has happened in the third COC meeting, and RP submitted a withdrawal application. The applicant comes here, he's stating that I should get a notice and I should be heard here. So in this case, open the PPT. What was the decision?
Form FA has not been filed.
Yes, sir. Form FA has not been filed. The decision of the appellate tribunal, the appellate authority held that jurisdiction of the authority tribunal under section 12A of the code is very limited. Sir, it is a very important point, sir. It is a very limited. Sir, in the previously, whatever the IP as practicing, and they know very well that time there was a very difficult to withdraw one application once it is admitted, means it was difficult to make the withdrawal. Then the 12A was introduced. Okay. So thus the COC had approved the withdrawal of CRP corporate debtor with more than 90% of voting share. It is not open to authority or tribunal in law to reject the application. So this is the main thing. This is first one is the code is very limited. Limited means why it is written limited. First of all, whenever 90% voting will happen, then this could be withdrawn. And further, the appellant authority relied on judgment of Honorable Supreme Court in the matter of Rajkumar versus Nagaparajan or civil appeal number so and so, wherein a company director is entered to seek the withdrawal of an application initiating CRP, if is able to establish that he would be setting dues of the creditors. Further, in the instant case, the corporate debtor had already settled the dues of two operational creditors, so it will be and services to their satisfaction made a draft already in favor of MS Industries. The appeal was dismissed. Sir, the applicant is objecting that without his consent or without a FA form, consent. So how could this can be withdrawn? But there is the thing is that whenever there is 90% voting will happen by COC, it could be withdrawn. And as per the Honorable Supreme Court judgment, that is civil appeal number judgment, read the judgment. What was it? Rajkumar
versus Nagarjun and others.
Read the judgment. In K. N. Rajkumar versus N. Nagarajan and others, the Honorable Supreme Court had observed that a company director is entitled to seek withdrawal of an application initiating CRP if he is able to establish that would be setting the dues creditors. So this is not recovery forum. Someone will come and someone will be recovered. This is the main object, is that to revival and restructure of the company, the resolution. Three things, resolution. So if one existing director also coming with a proposal at that time, it could be happen also if he is setting with all the creditors. This is the judgment given by Honorable NCLT Chennai, NCLT Chennai. Next. Sir, any question, sir? Out of this case laws also, I request to my all the participants, out of this case laws, any of practical questions, because facing we can discuss.
Can you please confirm what was the decision in the 12A application withdrawal? Sorry, I missed that.
So the appeal was dismissed and the withdrawal has happened.
Sir, I have a question on this.
Yes, sir.
In this section 12A, it has
Yes.
been mentioned. I will read for all the person. The adjudicating authority may allow the withdrawal of the application admitted under section 7 or section 9 or section 10.
Yes.
Now, on an application made by the applicant.
Yes.
So here,
Hmm.
the applicant mean initial applicant or applicant to the withdrawal. So here they have specifically mentioned the word applicant. With the
Yes.
by the applicant, what does it mean?
Sir, before formation of the COC,
After
appli-
formation, I am talking about after formation of the COC.
after formation of the COC, the RP will be the applicant, sir.
Okay. Okay, the applicant role will change at the time of without you mean to say before formation of COC, the original applicant of the process will be the applicant. When the COC is formed, then the applicant will be read as RP, because form FA has to be signed by the RP.
Yes.
So, but it is not clear. I will take your wording for the
Yes.
future, that applicant means the two different person at two different stages.
You are correct, sir. You are correct.
Thank you, sir.
Sir, any practical question, sir? Will you help us, sir? Everybody are well acquainted with the judgments and discussion, but I thought I will get a lots of number of questions where we can discuss and improve our knowledge also. Any interesting experience or any practical experience what we have got, that will be helpful, sir.
Sir, my one question is there.
Sir.
I'm Golecha from Mumbai. Regarding that, when auction sale is being conducted in liquidation matter as a going concern under
Yes.
regulation 32E,
Yes.
okay, E or F. So what is there? The word is mentioned that assets and liabilities are to be, company's assets and liabilities to be auctioned.
Yes.
Company as a going concern with its assets and liabilities. Okay, my question is that when in liquidation, when company is being purchased, then he is paying. Okay, for assets he will be honored, that's fine. But liabilities, how he has to pay that? Again, he has to seek the relaxation from the NCLT. Why this word has been incorporated? Because for liability, he is paying for assets, plant and machinery, land and building. Then why liability has been incorporated in the regulation? That is my one question.
Sir, what the practical exposure and experience I am telling, whenever there is a going concern sale will happen, sir. Sir, at that time, normally one application has to file, that is some waiver condition, waiver conditions with authority, like a resolution plan. So in that plan, sir, like a resolution plan, you have to prepare, suppose what are the waiver and what are the exemption, what are the deletion, what are the addition you want to take care in this assignment. That should be properly mentioned in table wise and category wise. So that is in the different types of cases, different types of suggestion, different types of implementation. At that time, authority has to be check that things very good way, and what is in his jurisdiction, he will provide, and what is not in jurisdiction, he will leave it. Sir. So one question, one example, sir. Suppose one of the sick industry has taken by the one of the as sale as going concern liquidation stage, and there is from the CSID, suppose that is Chhattisgarh Industrial Development Corporation, whatever. At that time, what happens? In that case, suppose as per the that is the Industrial Development Corporation rule and regulation and act, if there is a change in management, they have to pay a premium of 5% of the existing land value. Sir, my question, sir, understand, sir. I have purchased this company as going concern in liquidation, but as per the Land Development Industrial Development Act of the state, saying that if there will be change in management, I have to pay more than 5% of premium to that authority. So in the liquidation, already land has been valued, land value has been given, and I have paid. Again, I have to pay extra 5%. So at that time, I should I approach to the honorable authority to make exemption from me? Whether the honorable authority has power to exempted in that case, that is important. So you put that if the authority has the power, he will exempt. If the authority has no power, he will not exempt it. Again, if that is not satisfied, we can approach to the honorable NCLAT also.
Acha, one question is that another one regarding that ongoing sale. Okay, in ongoing auction is conducted. That's under regulation 32E.
Yes.
And the auction purchaser pays the entire amount within 90 days. He pays all the entire amount. Then liquidator has to issue the sale certificate.
Yes.
And that sale certificate is to be required the approval of adjudicating authority, NCLT, or he can hand over the possession to that auction purchaser.
Sir,
32E.
sir, sale certificate approval is not required, I think.
In ongoing sale, 32E. It is not required. Then he can give the possession to the auction purchaser, and he will apply for exemption and relaxation and that approval and after that process.
Sure. But one thing, sir, remember, suppose you want to sell going concern, you have to sell within 90 days. If that is 90 days is covered, then you have to make an application to authority. At that time, you have to make an application to authority.
Sir, my view is different. My learning, there may be gap. As per my understanding, sales letter must be approved by the A before handing over the possession or anything. Because we are not independent people. We are working as an officer of the court. For everything, we have to apply to the court. We cannot do the adjudicating work by our own.
So, whether it is a sale as going concern or
yes, yes, as a going concern, we are discussing, sir.
Ashokji, you may be having some view on this, no?
No, that what is there? I have gone through the case law. I find in case law where possession has been given, NCLT has never made any objection that why possession has been given, and they confirm the sale also. Relaxation has been given, but
it means
what
it is
the
established.
regulation is not clear.
No, regulation does not permit that.
No, regulation. There is no restriction, sir. In this regard, there is no restriction.
No restriction, no permission, no restriction. Also, it is in matter of interpretation.
Sir, in case of the private sale, that will be different, sir. Private sale. If you are going for a private sale.
No, it's going concern through auction. But what is there, sir? In resolution plan, okay, in CIRP, we will
Yes.
not hand over the possession because resolution plan is to be approved. After that, he has to make the payment according to resolution plan. He will. In liquidation, he is making payment. All payment is being made. Now,
True.
auction purchaser wants that when all payment has been made and sale certificate has been issued, now relaxation is to be permitted, then he should get the possession. It is quite different. It is similar to resolution plan, but some different from resolution plan also, because in action he will pay entire the amount.
It seems
And
your
after paying the
statement seems logical, and you also it is also supported by AA order you are telling, na? So we'll take as a rule. We take as an understanding.
what is there, when I have gone through some case laws, I find that it is mentioned that sale certificate has been issued, possession has been given, payment has been received, possession has been given, and relaxation has been sought and relaxation has been approved. It means relaxation and approval of sale has been given by AA. They, after that, giving the possession. There is no comment of NCLT that why possession has been given or not given, nothing there. So there is no clarity, na. So,
How, sir, may
little
clarify.
bit
Sir, normally whenever you are issuing a sale certificate, what are the conditions you are writing, sir, please?
so standard whatever sales
Yes.
certificate, there is no
This,
format
sir,
also.
see, I think I have seen one of the certificate. That is, it is a subject to approval of the AI also. Your sale certificate will issue. Subject to approval of AI. When the subject to approval of AI, if you will not give the sale certificate, that means he cannot come with the exemption part, sir. Exemption application. What is the local standard to come here?
No, sir, please, I could not get. When sales certificate has been issued,
So
and he will, whether liquidator or auction purchaser will apply with the NCLT for some relaxation and exemption. That's there.
Yes.
So what are you telling, sir? I could not get.
Sir, in there must be a condition, you see. There must be a condition, sometimes it is written.
Sir, Ashok sir, what will happen to the liability side? Because extinguishment of the liability cannot be done without the approval of AA, order of the AA.
Now that they used to apply in the with the NCLT, and executing authority approves it. Even in decision, it is clearly mentioned that his intention is to purchase the assets. He is not liable for, and he will get the good slate. Some word is there, so he is not liable for liability.
He will get the asset transferred in the new company's name.
Correct.
Okay. Thank you.
That is the simply. I want to some more clarification in this regard.
Yes, sir. Yes, sir. Next.
Vikram Kumar, proprietor versus Aranka Mumbai Private Limited. So in this case, the appellant had invoked the guarantee seeking repayment from the guarantor. As the guarantor had not paid in response to the invocation of the guarantee, the appellant had filed application under Section 7 of IBC for initiation of CIRP against the corporate guarantor. The NCLT Mumbai, via white order dated 9/2023, had dismissed the application as not maintainable on the ground that financial creditor had invoked the corporate guarantee on 25/8/2020, which is falling under the period specified under Section 10A of IBC, and for which CIRP cannot be initiated.
Sir, this is a case that it is indicating the 10A time period, that is suspension of the CRP period. I think we all have the experience in COVID, there is a suspension of the 10A case. So what happens here? Actually, there is 2 points. Open the case study in PPT, please. Go to the factor, please.
The appellant had invoked the guarantee seeking repayment from the guarantor. As the guarantor had not paid in response to invocation of guarantee, the appellant had filed application under Section 7 of IBC 2016 for initiation of CRP against the corporate guarantor. The NCLT Mumbai Court 5 by the order dated 9/2023 had dismissed the application as not maintainable on the grounds that financial creditor had invoked the corporate guarantee earlier on 25/8/2020, which is falling under the period of specified under section 10 of the IBC and for which CRP cannot be initiated.
Sir, in the plasma 5. So actually the thing is that in this matter, the notice was issued on what? Notice was issued since the corporate has invoked on 25th August 2020. And notice since as per the provision 10A, CRP could not be initiated in 12 months from the okay, sir. So it was invoked on 25th August 2020 during the 10A suspension period. But there is an important thing in this case. That is senior, that is the respondent has given the clue that they have issued the letter on 11th June 2019. That means before the suspension period. This is the case major thing. Major thing is that the respondent here is stated that he has issued the notice on month of June 2019, but as per the application, the notice in the that is 25th August 2020. In this case, the very important is that the learned senior counsel appearing for the respondent's corporate guarantor through its he also point number 5. He also drew our attention that page number so happy for giving calculation claim wherein the interest due has been calculated so and so date. Learned senior counsel stated that the letter dated 11th June 2019 issued by the applicant was addressed to Mr. Hemendra Aram and Ms. Gitanjali Sinha and was not addressed to the corporate debtor. We draw your attention to the pages 178 to 172 appeal paper book, wherein the respondent has drawn attention of the appellant advocate to the fact Mr. Hemendra Aram and Mr. Gitanjali Sinha are not director of the respondent. So the submitted the said letter 11 June 2019 cannot be said to be invocation of the guarantee given by the corporate. Sir, here the corporate debtor, the applicant has stated that I have invoked the guarantee in 2019 so and so date, but the invocation was happened 2020, but the corporate that here is the respondent is relying on that he has issued a letter to one of the that is the Hemendra Aram and Gitanjali Sinha, but these two are not the director of the company. So this section, as per the 10A suspension, this application should be dismissed, and this cannot be admitted under CA.
So, sir, conclusion is that under CIRP, guarantees by the directors can only be invoked. Is that conclusion?
No, sir. Under the suspension period, CIRP cannot be initiated. Actually, this is the application was filed during the suspension period. Sorry, the corporate debtor invoked the guarantee during the suspension period, and the date was during the suspension period.
Date of default falls within the suspension period.
Yes.
If the date of default falls in the suspension period, as per Section 10A, the CIRP can never be initiated against that
Yes.
corporate guarantee.
That is 10A.
Correct, sir?
Yes, sir. Great. Sir, or anything new experience, new question of law, sir? We are interested to hear from you also.
On a separate thing, can in that case a civil remedy be taken or no?
That is civil remedy.
For guarantee, for invoking the guarantee?
That is always available, sir.
That is always okay. Thank you. Just seeking that clarification.
Sahoo sir has to approve. I am not a authority on that.
Civil remedy is there, sir. All our
This sir, one sir,
So my
this
civil-
suspension period is regarding Corona period suspension, na?
yes, sir, that is.
Okay.
This is a Corona has gone after a long period. New case has gone. Or any more cases? We have not prepared any more cases, so we have prepared some similar cases. These 7 or 6 cases. So I hope we have some time. We can discuss some more cases, sir. If anybody will share one experience, then we can give a remark and feedback. We can conclude that. I have a question, sir. I have asking myself one question, sir. Sir, after filing dissolution application, the company will dissolve. Now the financial creditor is coming with to make initiation of that is personal guarantors insolvency, PG to CD. Sir, when the company is not in a stage, it is dissolved, whether the guarantors are liable to repay.
I think yes, sir. Because the company is not there, but for that entire amount is not paid, na. Company even and bank's outstanding is there. Suppose it is not IBC and it is outstanding in the books of any financial creditor, and company is dissolved due to any other reason, then it doesn't mean that he cannot mortgage property or other guarantors. I think he should have right. Financial creditor should have right.
Entire chapter 3 is based on that, sir. Otherwise, entire chapter 3 will go away of personal guarantors if this is not the case.
But sir, limitation period has to be seen, no?
No, that is
Sir,
fine, but whether it is co-substantive or not, that
Guarantor
is the question.
guarantor liability is coextensive.
Correct. And that's why this IBC chapter 3 is there. Otherwise,
Yes,
I don't
sir.
know why this question is even coming.
So if that is company is dissolved, what is the coextensive?
Company is dissolved, not the liability. Guarantee was a liability.
Sir, company is
If-
dissolved under certain condition. As per my understanding, as per Companies Act, even that company can be, if there is some negativity is found, that can be name can be activated for 20 years after dissolution.
Yes.
So the company
Because I have faced such question. This question will be matlab ki analysis that is as per the learned friend, my senior. Chapter 3 will be deleted. If it will be, there will be any problem will.
Even if I apply for the strike of the company in this year, in 2023, my company gets striked off. from the registrar side, even that I can revive that company in future if there is no default, etc.
Yes,
Even
yes.
so, this point, there must be some case law on that. Whether corporate, that you can tell in a better way.
No, sir,
Sir,
I am asking myself also. This is, I am searching. I have faced 2 or 3 times this question. Okay, but I am not quite confident. But the normal practice is going on, so that will be continuing. The application is going continuing, sir. EG2CD application is continuing after resolution also, sir. Yes. So anything else, sir? So I think this is a small time I have given. So I hope we'll conclude here, sir. The better I will prepare due to some puja vacation in Orissa. We are moving to other places also. So next time we'll meet and anything. So I request to my all the learned seniors and my friends, and they will, if there is anything mistake from our side, they will be.
So it will be part 3, Mr. Rana, not chapter 3, just clarify. And so the adjudicating authority will be NCLT also only in this case, right?
Yes, yes, sir.
Not DRT.
Many things cleared now. Many things cleared, sir. Now it is coming to a very crystal clear pictures. So, but PG to CD is something has to be clear very soon. Many of benches is not also giving the admission priority in PG to CD, I think. If,
They are waiting for Supreme Court's order, so which is listed again in November now. So till then, no bankruptcy order and no personal guarantees is getting admitted now. They are again on hold.
They are also that is going to delay. And when it will come, it will be clear. Picture will be clear.
So section 94 are going on now because there is no stay for section 94 because the
No, there is. Even 121 they are holding. Bankruptcy is not even under challenge. But still, no 94, no 95, no 121, nothing is over.
that is there, but specifically Supreme Court orders was section 95 now, where the banks have gone.
We can discuss this, sir, but that is the current scenario. There is no hearing. They simply give dates. That's all.
Yeah.
They're simply giving the dates and dates.
Yeah.
But some of cases they have appointed also RP.
In fact, 94. In fact, 94. The person himself is saying, "I'm insolvent. Admit me." Even that is under. They are giving dates. I don't know what is the reason behind that. That can never be under challenge. If somebody himself.
Gets offended, so let's not make any comments.
No, so we are not talking anything on bench or something. We are just saying we are discussing here. It's an open forum discussion between RPs, right?
Because
so
of
we are
section
not saying
95, the moot point is that the opportunity of being heard has not been given. But here, this is not the question in 94.
Exactly. There is no At best, it can be a fraud. At best, it can be to defraud your creditors, right?
That will come to know only when the RP will be appointed, na? Yeah.
Absolutely. Other than that, why they are staying it, I don't know.
Yes.
And that is going on for 2 years.
Yes,
I filed
exactly.
one 2 years back and still not admitted. So things are like this.
But though there are some of the orders are there.
Some of has been admitted. Some of has been admitted, but stay by the High Court. In my one of case also matter is.
Sir, I admit I got one. I finished one CIRP personal. Then we filed 121 for bankruptcy. Now that 121 is under stay. Stay in the sense no date, only dates are coming. No result is coming on that.
Okay, sir.
If NCLT has not to given only dates are being extended, so I think they should keep the matter sine die, subject to the decision of on place of giving dates.
That is what is happening. It's actually sine die. But it's not said that it's sine die, but actually that is happening. So they say, okay, 94 date, 94, 95 dates. That's all.
No, they should not list also. I think that they should not list and after.
Sir, we are not registrar. We are not registrars and we are not NCLT.
But they just ask the next date of hearing in Supreme Court and they give the date beyond that.
Correct. Absolutely.
We have to live with that. No issues.
So can we close the session now?
Yeah, please.
Okay, sir, this was the end of our session. Anjali madam.
Thank you very much, sir.
Yes, thank you.
Thank you, sir.
Yes,
Thank
sir.
So
Madam, we are leaving, then session is closed.
Thank you.
Thank you very much, sir. Such a nice and interactive session. You are requested to share your PPTs, please.
yes.
Thank you. Please share the
Thank you, sir.
Is the webinar is over or there is going to second session?
Yes, sir. It is over now.
Okay, there is no second session because time was mentioned up to 5 o'clock. That's why I was just confirming it.
Sir, it is over now.
Okay, so we can leave, right?
Yes, sir. You can.
Thank you. Thank you, sir.